Hey, hello, everybody, and welcome to today's session on the day in the life of an elder abuse case with Shannon Miller and Ellen Cheek. Shannon Miller is a Florida Bar Board Certified attorney specializing in elder law, practicing in Gainesville, Florida. In 2012, Shannon served as a drafting member of the Financial Exploitation of Vulnerable Adults Work Group, led by Florida State Senator Kathleen Passidomo. That statute became law in 2014, creating groundbreaking tools for law enforcement, prosecutors, and civil practitioners to crack down on the exploitation of our most vulnerable citizens. In 2018, Shannon, as part of the elder law section, created new legislation relating to injunctions against exploitation and freezing stolen assets. Shannon has been instrumental in rolling out the exploitation injunction law across the state of Florida and is currently advocating for changes to the exploitation injunction law to make it more accessible as part of the elder law section. Shannon has served as the president of the Academy of Florida Elder Law Attorneys and currently serves on the Florida Joint Public Policy Task Force for the Elderly and Disabled, served as chairperson of the Legislative Committee of the Elder Law Section, and now serves as secretary of the Elder Law Section Executive Committee. Ellen Cheek first began to focus on elder law issues in 1975 as the staff attorney for Senior Advocates, a unit of the Legal Aid Society of San Mateo County, California. Since December 2005, she has been a staff attorney for Bay Area Legal's Florida Senior Legal Helpline. Ellen is also the Florida Elder Justice Coordinator and the co-chair of the Florida Bar Elder Laws Section's Abuse, Neglect, and Exploitation Committee. Ellen's an honor graduate of the Mount Holyoke College and the University of Santa Clara School of Law. So thank you, Shannon and Ellen, for joining us today, and take it away.
Well, thank you, Kathy. And good afternoon, everyone. As you can see, I'm Ellen Cheek, and this is my colleague, Shannon Miller. And Shannon and I have a lot to say about most things.
Wait a minute, Ellen. I need to correct something on the record.
Yeah.
Okay.
Yeah.
All right. And this is probably how this is going to go, you guys. So we're going to do a lot of push and pull. We want you asking questions throughout the presentation. But I heard Kathy say that, Shannon, the exploitation injunction, the true creator of the exploitation injunction statute is this person on the screen with me, which is Ellen Cheek. I remember we were looking at a West Virginia draft statute. It was Ellen Cheek, Nancy Wright, and I in my conference room. And Ellen was saying, hey, this looks like something we could use in Florida. And that is where the exploitation injunction statute initiated from. So we're going to talk about that more, but I'm sorry to interrupt, Ellen. I just had to correct that little issue there.
Well, you see, what I was going to say is that Shannon and I have a lot to say about a lot of things, but we really have a lot to say about abuse, neglect, and exploitation. So I'm going to get started right away. And I was thinking about it, and certainly elder abuse, neglect, and exploitation is not a new problem. But this emergence of targeted state laws and specific legal remedies to address the issue is relatively new. And Florida, as Shannon said, and as Kathy mentioned, is a prominent case in point. Chapter 825, appropriately titled Abuse, Neglect, and Exploitation of an Elderly Person and Disabled Adult, has been revised extensively and has grown significantly in just the past 8 years. The 2014, 2018, and 2021 legislative sessions all produced signed legislation, new Florida laws relevant to this issue. And all this activity indicates, I think, both the gravity and the enormity of the problem. And in many cases underscores the fact that abuse, neglect, and exploitation of a vulnerable adult is a crime, And not surprising then that you find Chapter 825 in Title 46 of the Florida statutes, which is simply entitled Crimes. So in Chapter 825, you'll find detailed definitions, criminal penalties, and civil legal tools, which brings me to the goals of today's presentation. Shannon and I hope to focus on Chapter 825 and the related statutes and define the current law regarding abuse and financial exploitation in particular, and the newest developments. We want to illustrate the definitions in practice. We want to acquaint you with some of the available legal tools and the practical tips for their use. And we want to share some of the newest developments in the ever-evolving science of aging, which will undoubtedly affect all of our practices because of the insights it is providing about capacity and about exploitability in an apparently competent adult. So lots and lots to cover. Shannon and I will be interacting with each other, and we hope to be hearing from you as well. But we're going to begin now, without further ado, to look at what Chapter 825 says about exploitation in Florida. And no one better to start us off than Shannon Miller.
Thanks, Ellen. Okay, so please, as a question comes up for you, put it in the question and answer or in the chat, and we are going to interrupt the session to answer your questions, because if we wait until the end, you're going to forget what your question is, or it's not going to be timely. So as your question comes up, please ask it, and we will be happy to answer those questions, hopefully, unless we get, an insane amount, which I don't think we will. And we also like to know that you guys are awake out there. So I'm going to do the thing that I always do when we have one of these presentations, is I'm going to walk through exploitation. And I know a lot of you have heard me do this repeatedly, but the definitions are so important, and it's so important that we understand what the law is in Florida. I personally have a marked up, tabbed, underlined copy of 825.103, the new version, because remember, we had all these updates in 2021 that is incredibly amazing to watch. And you're not going to find it on the online version. You actually have to go to the legislation to find the new version of 825.103. But let's quickly walk through those definitions, because they are so important to our foundation of understanding everything that comes next. So 825.103 is the criminal definition of exploitation that creates the foundation for the injunction. It also creates the foundation for the 772.11 civil theft, which creates treble damages. We have to provide this notice, but that criminal definition of exploitation creates the basis for the criminal case in 825.103, for the injunction statute in 825.1035, and then for civil theft under 772.11. So we need to be comfortable with all three of those statutes. The most important one is 825.103. So let's quickly walk through the definitions, the different ways to define exploitation. And there are 6 of them. The first one is, I like to call it theft by a helper. What that means is you've got a helper. They can be a care provider. They can be a family member. They can be someone you have a business relationship with. It's someone who's helping our vulnerable adult, and they borrow money. They try to steal money. They may not have even stolen the money, but they make an attempt to remove assets from our vulnerable adult. That is exploitation under the first definition. They just have to have a special relationship with our person. And I'm just going to add this in as much as I can, because it's so important. And all you prosecutors out there, all you adult protective services investigators out there, consent is not a defense. That means She gave me the money. She gave me the property. She wanted me to use the $25,000 because my, for my bankruptcy, whatever it is. Consent is not a defense under the 2021 statute. It's been laid out very clearly under the Attorney General Elder Law Section version of 825.103. It specifically says in there, consent by the vulnerable adult is not a defense to this crime. Okay, so it's a huge change. We had some case law that was not very friendly to us, but the the new statute from 2021 that became effective in July clearly says that gifting is not a defense to this statute, to exploitation. Okay, so yay. All right, so now that that's cleared up, our second definition of exploitation is that the exploiter knew or should have known that our victim could not consent. Now, this is the only definition that requires an actual proof of inability to consent. This is the only one that requires some level of incapacity. And I go back to the scenario that I always use on this one, and that is my little lady who went to the Cadillac dealership and bought a Cadillac, drove off the lot, crashed it into a tree, went back to the dealership. They sold her another Cadillac the same day. She made it all the way home, but then crashed into the side of her house, went back, got a third Cadillac that they sold her. At this point, she didn't have enough credit to purchase the third Cadillac outright, so they leased it to her. That the Cadillac dealer knew or should have known that they should not have continued to sell her those Cadillacs. Now, what did we do in that scenario? We sent them a civil theft demand. We said, clearly you knew or should have known. They agreed, and they wrote us a check for the full value of those 3 purchases. Using the civil theft demand process can get money back into the hands of our victim very quickly. But that's the second definition, knew or should have known that our vulnerable adult could not consent. The third one is bad acts by an agent under power of attorney, trustee, or guardian. That's what I call it. That's not the actual definition. I'd encourage you guys to actually read the definition. But basically, our most popular one is when the agent comes in with a power of attorney document, and in the power of attorney document, it says the agent can gift to themselves. It says they can self-deal and they can gift to themselves. And so when the police officer shows up and says, hey, we saw that you were using your power of attorney to gift a car to yourself or to take your family on vacation, and that you can't do that. And the agent says, well, it says right here in the power of attorney that I can. And the law enforcement officer is like, oh no, wait, what do I do? What do I do? Right? And so we know that it doesn't matter what the durable power of attorney statute says, because the law is such that unless the agent operates in the best interest of the principal, that's the person giving the power away under the power of attorney, or they operate, best interest of the principal or for the benefit of the principal, like it's for their benefit some way, then those types of transactions are not allowed. Even if the document says they have the ability to gift, and even if our victim consents. Thank you, Attorney General and Elder Law Section of the Florida Bar. So no longer can you take that durable power of attorney document, go to the bank, use money for yourself, and think that that's not a crime. It is a crime. And we need to educate everybody who's going out to investigate these cases to understand that using a power of attorney, even though it authorizes gifting, is simply not allowed when you're dealing with a vulnerable adult. It must be for their benefit or in their best interest. So gifting yourself the car or whatever using their money is not allowed. And it is in fact a crime. The fourth, that includes trustees, trustee and guardians. If they are in fact violating their fiduciary duties, then they also are committing exploitation. So, in that scenario, I talk about the trustee who was the sister of my lady. Who was the brother of my lady, and he bought with the trust money a house for him, a place at the beach for $240,000. And that in fact was exploitation, even though it was in the civil arena, right? So if you're a trustee and you commit a violation of your fiduciary duties, not only can you be held civilly accountable, but you can also be held criminally accountable. And, we also had this big case that, where our exploitation defendant was actually exploited his mother. He was a trustee. He stole $2.5 million from her. After she died, our local law enforcement prosecuted the case. They executed search warrants, found out that the money had been spent improperly, and he pled guilty to the crime and was actually sentenced to 12 years in prison for that really bad exploitation case. So not only is it theoretical, we're actually seeing these cases prosecuted when we have good state attorneys and good law enforcement officers investigating these cases. And guess what? We have good judges who are actually providing good sentences and looking at these cases as though they're crimes just like any other crime, which is very refreshing. So we're getting there. Yay. All right. Joint account theft. This is my Miss Maddie case. And Miss Maddie was my dear first exploitation client who came in. I was a young lawyer, and she had retitled her assets with the pastor. So I should back up. Her husband died. She had $115,000 in assets. And at her husband's funeral, the pastor came to her and said, I know you don't know how to manage your finances. I can help. Why don't you add my name to the bank account? She said, thank you so much. I'll do it. She added his name. He cleaned out the entire amount, the whole $115,000, put it in an account with his name and his wife on it. And we spent the next 2 years trying to get the money back. We ended up getting half the money back, and she died a couple of months later. She was 94. The stress of that litigation was terrible. We ended up getting half the money back. And now what we know is, had we had the exploitation injunction then, like we do now, she would have come into my office, and probably that day or the next day, I would have filed our ex parte injunction petition. We would have been able to freeze the assets in his account. Even if his wife was named on the account, we still would have been able to freeze that account. And that account may have included their own money. And we would have been able to undo what happened in that case literally within 2 weeks. So that, I love that, that joint account theft is not allowed. I always like to forewarn people that if it's a joint account and our exploiter puts any money into the account, then this case, that type of exploitation can be problematic to prosecute. So make sure that you look at the actual statements to be sure that that joint account holder hasn't put money in. There's other ways to get the money back. You're not lost, because we have so many definitions of exploitation, but that's one way, it's just one thing to put on your radar. Negligent mismanagement of funds. That's when our payees, usually under Social Security, have negligently, like, they don't even have to use the money for themselves. If they just aren't using the money for the benefit of the principal, that also can be exploitation. And then our sixth definition, which is a permissive presumption against exploitation. I'm not going to spend too much time because we'll run out of time, but suffice it to say that if there's a relationship of less than 2 years and there's a transfer of $10,000 or more, and even if that person is not what we would call a helper, so they are not a family member, they're not a caregiver, they're not a business relation, the court can find that if they meet the elements, that case can be handed off to a jury in a criminal case, and the jury can decide that exploitation has occurred. And I know, I was like, no one's ever going to use this, but there are prosecutors, and I give them real credit, in particular in Palm Beach County, that are actually prosecuting under the permissive presumption statute. And they are using it, they're just adding all the definitions on when they prosecute these cases. But really that permissive presumption becomes most effective when we have someone who's like a repeat offender, right? They're an exploiter who has started targeting people and is doing this behavior again and again. When you can bring in that other evidence for modus operandi, which is like you're doing the exact same thing again and again, and we can prove that you're actually targeting people, we can find that this particular type of exploitation we're going to get the jury to find them guilty. So yeah, it's a good one. So those are the definitions. And I'm trying to be mindful of the time because I can go on and on. But let's talk for a short minute about the new AG law and what it does. And I've already told you one of my big things is that it basically makes gifting not a defense to exploitation. I'm going to run quickly through some of the other important things that the 2021 law does. And the first one is that it allows the statewide prosecutors to prosecute exploitation cases. Now, what do I do as a practitioner with that? Well, I'm always wanting to get a criminal prosecution of our exploitation cases because we get this thing called restitution, right? And if you have a defendant who has a restitution order over their head, and if they don't pay the money back, they're going to jail, that is really a lot better than a civil judgment. So the restitution order is always good, plus the fact that I want to get these people off the street, right? I want these exploiters to go serve a little time because it's a crime like any other crime. And if we don't put them away, then someone else, they're going to continue to do this bad behavior. So, there's a lot of reasons why I try and get these cases prosecuted. If I have a statewide prosecutor in the background and I go to see the state attorney and I say, look, I really hope you will prosecute this case. And they're like, oh, it's a civil matter. I don't think so. I don't think this is a good case. This isn't something we should prosecute. Then I go, okay, well, I'm going to take it to statewide prosecutor because I think they might be interested in this case. It's funny, all of a sudden there's a little change. Now they're like, wait, show me that case again. So, nobody wants to have their jurisdiction taken by a statewide prosecutor. So it gives us a lot of tools to go in and get cases prosecuted. So I love having statewide prosecutor behind this. Okay, that's the first one. The other one is exploiter disinheritance. Yay! This was an elder law section, huge thing that the elder law section wanted to see and legislated. We had a lot of pushback from another section of the bar. But honestly, getting the attorney general to help us get this through was amazing. So what that means is if you're convicted of exploitation, like the case I was telling you about with the 12-year sentence, in addition to that, we were able to basically act as though he had died before our decedent died, okay? Which means that he was excluded as a beneficiary from her estate because he had exploited her. Before the statute, we had to litigate that issue. We had to go into court, file lawsuits to get the exploiter to not inherit the money that he had stolen, right? So he steals the money. There's a little bit of money left, and then he's going to get a third of that money again, even though he took like most of her money. So this has created a new, it's similar to the Slayer statute. And this has been really helpful. And I personally have used it already. So it's really great. It's going to become a great tool for us. It also limits the costs of, exploitation litigation. It keeps prices much lower to recover assets for our people. Criminalizes kickbacks for improper benefits. And the way that this works, you guys may have seen this. We do have some facilities across the state that will bring in some of these exploiters, and they have our vulnerable adults sign durable powers of attorney or other types of agreements. And basically they steal money from our vulnerable person who's in the facility who maybe doesn't have anybody watching over them. So what's happening now under the statute is that facility that's bringing that exploiter in and making a referral fee is going to be now held to the same standard. They also are exploiting by doing that kind of kickback arrangement and bringing exploiters in. So it's really great. So we really love that. Also criminalizes intentional isolation or restricted access to a person from family members. So like that one we've used as well, because what we do find is oftentimes our exploiter will isolate our victim, right? We had a case where our exploiter, who was a family member, who was a spouse, she was a new spouse, she was taking our little guy and moving him from facility to avoid the family finding them and finding out that she had taken all the money. So, now we have the ability to say, look, that's also a crime. So you better watch yourself. So that intentional isolation is very important. As to be, criminalized. And it can include against guardians. So we do want to be very mindful that, isolating our people is not okay unless there's a real reason to protect them from somebody who's trying to exploit. It also criminalizes intentional modifications of someone's estate plan. Oftentimes we have a situation where the exploiter will move all the real estate into their name. They will take all the money out of the bank accounts, make themselves joint account holders, make themselves beneficiaries under the IRAs. Well, the other thing that they do is they may go online and make a new will that makes them the beneficiary of the estate, or they take them to an attorney who makes the exploiter the beneficiary of the estate. Well, this criminalizes that fourth element so that we don't have to wait until the person dies to undo that will. It's a crime. It can be undone while the person is still living. So it's a huge help for us. And then the final issue, which is maybe near and dear to your hearts, is that the new law allows agents under power of attorney to file exploitation injunctions, even if the victim is not consenting. And this happens a lot. I know it seems hard to believe that your victim has had all their money taken by this exploiter and they don't want to prosecute. They don't want to have the assets back because it may be a family member, it may be someone that they love. They've been convinced that this is what is good for them. And so if they have that exploitable brain, it is very, very difficult to get them back to understanding that they have been exploited. They don't see it that way. So this new provision allows our agent under power of attorney to file the exploitation injunction without filing a guardianship. You can actually file the exploitation injunction without filing the guardianship, and you don't have to have consent of the victim. So that's another very important part of the Attorney General bill.
Shannon?
Okay.
Yeah. Ellen.
And there was one more thing, I think it was in the 2021 provision that is really important for the safety of a victim. It allows the injunction to be continued if the hearing is continued. It was a little glitch in the first iteration, in the first version. You could continue the hearing for the final injunction, but you couldn't necessarily continue the protective injunction. Now you can match it, right?
Yeah, it creates a very small window for continuances. And so I want to kind of think about the injunction as it's not litigation. It is, do the facts meet the elements of the injunction statute? Is there an exigent circumstance? Is our person clearly being exploited? Okay, it's an injunction. It's like the judge is supposed to take a snapshot and look at it and see, do these elements exist? And if they do exist, then we're going to do a few things. We're going to undo your new document. We're going to have a no contact provision with our victim. We're going to undo a pay on death beneficiary or a joint account status. We're going to take action under this injunction. And that is done intentionally as like a one-time event, right? So
it's meant
we
to be
don't,
temporary.
right. So we don't really want these ongoing continuances to take like depositions or to have discovery. It's supposed to be like you're in and you're out. An injunction is always subject to modification. So once it's in there, anybody can file a motion saying there's, you have to meet the standards for modification, but it is important that we understand this is not intended to be a civil litigation process. It is just similar to this one-stop shop. So my feeling on this always is I do not want a bunch of continuances because then judges are going to think that this is supposed to be a litigation matter, and it's not. It's like you go in, you have your hearing. Do you meet the criteria or do you not meet the criteria? So I'm glad they have a little temporary continuance for a very short window. It's like 15 days. It has to be for cause. And basically it's to allow our victims to be able to serve the exploiter, right? So if you can't get service on the exploiter, it's giving us a little bit of time to do that. But we do not want to open this up to a whole bunch of continuances because they want to take depositions and they want to do discovery and all that good stuff, because that is not what an injunction is for.
Mhm.
So yes, I'm glad we have a little bit more time to make sure we get our person served, but I do not want to turn this into, and that's why some of us were really fighting any longer of a term for continuances, because I want it to always be viewed by the court as like, you either have it or you don't. And then the judge dismisses it. You can come back and file another petition for injunction another day, fix whatever you've got wrong. If you didn't do sufficient evidence, you haven't proven it's an emergency, you go get your stuff together, refile it. You can do that. And oftentimes we use the injunction. We'll put something in our initial petition that says, if the court does not believe that there's sufficient grounds to freeze the assets, to approve our temporary injunction, remember that gets us to the final hearing, Your Honor, we withdraw it. Unless we meet the criteria at the front end, we don't want you serving our respondent with anything. We do not
And
want them to
yeah.
even know.
And that keeps our victims safer. That is a lesson we learned in
Yeah.
drafting from the domestic violence folks.
Yeah, it's a little trick of the trade.
It's a trick of the trade. If the judge is not going to grant the injunction, the temporary, but is going to allow the petitioner time to supplement, no, because then the respondent will be served, and that can be a very, very dangerous time.
Okay, let me interrupt. We have a question in the chat, and then another one, I think, in the question and answer. It says, in that case of an agent filing the injunction, is there still risk that the power of attorney may still be revoked if the agent is acting against the wishes of the elderly person?
I mean, file your injunction at your own risk, right? So, I mean, some of the things that we do as practitioners is carefully vet the person coming in. So I'm not going to represent someone who doesn't come with clean hands. If there appear to be any transactions in the bank statements that I look at, and I do a very careful vetting process of saying, like, okay, when was this durable power of attorney obtained? Okay, and what is the, what about you? What have you received any gifts in the last 5 years from our victim? Are your assets intermingled at all with our victim's assets? It's very important that we don't engage in this tit for tat thing between family members, because, oh, well, she got a car and now I want a car. Well, now I'm going to get a power of attorney to get this person, but I myself don't have clean hands, right? Unclean hands. So yeah, it's very important for us to vet these issues, because it will bite you if you haven't done that. So is it possible that our agent may be acting not in the best interest of our victim? Absolutely. And you need to do a very careful job yourself. And this is just a little practice tip. Once your credibility is shot with the court, you're never getting it back. So if you come in with injunction petitions where it's not a clear case, it's gray, if your facts do not support the allegations that you've made in your petition, and you try and come back again with something and you're like, no, but this case is really clear, like, you're going to have to fight a lot harder. Keep your reputation clean, come with clean cases. Don't come to the court when it's a squabble between, this push and pull thing, because it doesn't just affect your case. It affects the judge's perception of all exploitation injunctions, because if they get repeatedly this whole thing about using the injunction process for this kind of battle in families, they will not take them seriously anymore. Come with your real exploitation cases and make sure you vet your petitioner and vet your victim. But on the issue of durable powers of attorney, could the durable power of attorney be set aside? Someone would have to move for that, right? Certainly someone would have to intervene, whether it's the respondent in the injunction matter or some other interested party coming in potentially could file their own injunction petition and could try and set aside the power of attorney that this person who's saying they're pursuing the injunction. And what you may end up with is a guardianship. Because when,
And the questioner followed up with that she wasn't implying that there was agent's wrongdoing, but just that the elderly person doesn't want to go after the wrongdoer.
okay, not implying there was agent's wrongdoing, but just that the elderly person, right, yeah, here's the thing about our people, and we're gonna get into the exploitable brain next, I think. Is that next, Ellen, or we're gonna?
It
wait
is
on that?
next, and
Okay.
this is probably a good time, but please answer,
Yeah, so our person who's vulnerable, like the thing is about them that they will go with whoever shouts the loudest with the most frequency, right? They get in the person's, our victim's ear, and they say, your family's trying to put you in a nursing home. I'm the only one who's going to keep you out of the nursing home. Your family stole money from you. Look, here's these fake credit card bills. And they can't perceive what the credit card bills say in some cases. They've stolen from you. It's like this mantra that's repeated again and again and again about, the wrongdoing of the actual people who are trying to protect our victim. So what do we do in those cases? We file our injunction petition. Even if our victim is still fighting us, we remove the exploiter from the presence of our victim. That's why the exploitation injunction statute is so great. It's almost better than guardianship, emergency temporary guardianship, because when the judge enters that ex parte order of temporary injunction order that freezes the assets, it also says exploiter cannot have contact with our victim. So we eliminate our exploiter from the presence of our victim, and then we bring in the real helpers who start to talk to the victim. Same idea. You explain the truth to the victim. You repeat it. You talk about it again and again. Mom, here's proof. Sometimes it gets through to our victim. Sometimes the victim is so attached to the lie that you can't make progress. And in those cases, a lot of times we end up with a voluntary guardianship. We end up with an incapacity guardianship. We have to do those things to protect our person, even if they have, literally been exploited to the extent that they have no assets left. If we get the money back and they're just going to do the same thing again, we have to have a protective tool in place, whether that be an irrevocable trust or, some other mechanisms that we have, like voluntary guardianship or incapacity guardianship, using a previously entered durable power of attorney. So we don't have to be in property guardianship. We can actually use the power of attorney to manage assets once our person's incapacitated, without fear that they're going to try and revoke it, or they're going to try and put a new agent under power of attorney in place. Is that clear, Ellen, or was that super confusing?
No. Well, the whole thing's super confusing because these are super confusing cases. These are human beings, and there's more than two sides to the story. There's always more than one side to the story, but this is why it's that removing that person is so very important, because the isolation of the victim and then the opportunity to repeat and duly influence them by repeating and repeating and repeating. That's the toxicity of the environment, really.
Yeah. And, I tell this story also because I think stories are compelling, and, many of you see it in your practices, but we had this case, I talked about it yesterday during my session, where we have our exploiter. They move in next to our lady who has a long-standing estate plan. Her kids are involved. They're the agents under powers of attorney. The exploiter comes in, he moves in next door. He's the handyman. She starts to pay him more and more money for doing work that is not, worth, the $1,000 checks that she's giving him every month. And then next thing you know, he's got his own power of attorney that she signs. He's now becomes the owner of several parcels of her property. She's given them to him and put them in his name. And then he comes and puts a lock on the fence around her house, and he's the only one with a key. He changes her phone number. He gets her a new cell phone that only he and she communicate together. And, in that case, we went down. Judge Morley, bless her, she's one of the queens of exploitation prevention in the state of Florida. entered an injunction, and we were able to separate our exploiter from our victim. And then as time went on, she started to see what was actually happening. And she had a lot of regret for what had happened. She felt very badly about what had happened and what she had to put her kids through. But, it's removing that exploiter from the presence of our person. And the threat of the removal, like, it's not just, it's a civil violation. No, it is a new crime if you violate that no contact provision, even through third-party communications. So it's a violation of injunction. And you guys know with domestic violence injunctions, when you violate that injunction, like, it's a big deal and it's a new crime violation. So it's very problematic. And law enforcement is really good about kind of explaining that to them when they serve the injunction on the respondent.
In fact, 825 has its very own what happens if you violate. I think it's 825.106. What happens if you violate one of these injunctions? And it's no small thing.
No.
Shannon, I think we can just quickly allude to the some of the new science,
Okay.
because it's really pretty neat, but we have so much to say.
I know, we do. Okay. So the new science is, well, let's talk old science. So this is an important distinction. And I think all of us need to start to really get our heads around the idea of incapacity versus exploitability. Okay. Incapacity means you do not have the ability to manage your affairs. You don't know how to determine your residence. You don't know how to make financial transactions, all the things related to your person, medical decision-making, anything about management in your life. We have assessment tools that allow us to determine, based on these assessment tools, whether or not you are, in fact, unable to manage your own affairs. Some of them are mini mental status exams, the slums test. There's all kinds of clinical evaluation tools that we have that are science-based that can tell us whether or not you have the ability to cognitively manage your affairs. So, for example, you guys will see, if there's anybody who does this stuff, draw a clock face. And if the face of the clock and the lines go outside the face of the clock, if they remember all the numbers, there's certain points that are attributed to certain things. You'll also hear them talk about count backwards by 100, by sevens, spell world forward and backwards. I'm going to tell you 3 things. You need to remember them in 2 minutes. All of these things are determinative of being able to manage your affairs. And this clinical research created the foundation for these tools to be used in incapacity proceedings. That's the incapacitated brain, right? And that's like back here, right? Well, what we know now in the exploitable regions of our brain, which is here, right above the temple, is that this is an entirely different set of problems in your brain. This creates executive function issues. This is things like, I cannot assess risk. I cannot tell the difference between the truth and a lie. I lack the insight into being able to distinguish something that is completely false. I don't have the ability to look ahead down the street and see danger. These are the things that we know with the thinning of the cortical insula, which is part of the executive function of the brain. We don't have a tool to assess that at this point. There are 2 small studies that have told us a couple of things. And the first one involves 36 people. Sorry, you guys have heard this before. My favorite study, who half of them were exposed to the scam. They took the bait. The other half were exposed to the scam. They did not take the bait. They were all put under MRI, and 100% of those that took the bait and fell victim to the scam had a thinning of the cortical insula. That little region of the brain that helps us assess risk, that helps us understand the difference between the truth and a lie. So the science is and that's like pretty much one of, I don't know, maybe 7 studies that are telling us about the exploitable brain. But right now there's a big research study going on through the University of Central Florida and the University of Florida. Natalie Ebner and Bonnie Levin, who spoke at our exploitation conference in 2018, who are really digging into this stuff. are creating a tool. They're creating a tool as part of this new study. And we are going to have the mini mental status, the slums for the exploitable brain. That's coming up. And hopefully we're going to get behind that legislatively in Florida, because we are ahead of the curve on this, to try and create the exploitable brain court. And the perfect example is you guys doing adult protective services investigations. You may go out, you may meet with your victim. The victim may have full capacity. You may assess them to be completely capacitated, but they're giving all their money away to their neighbor. And you're like, I'm so sorry, I can't do anything, because they've checked every box on the incapacity stuff. They're fully capacitated, but they're giving their stuff away, and you can't do anything about it right now under the 415 rules. Well, that needs to change. We need to understand the exploitable brain, and why it is that we don't have a tool to assess that is because we were kind of grouping them all together. Now we know these are two separate areas of the brain. They require two separate tools. This tool is coming. It's coming soon. So be on the lookout.
Be on the lookout. Alrighty, any questions so far? We can take a little mini break right here. Anything you want to ask before we go on?
Nothing's in the chat right now or the Q&A, so I think you can go on.
You
Okay,
guys wake out there. That's what we really want to know.
so
I'm sure they are.
you've heard the definitions. We're hearing about the science. What does this really look like when these people call? What does this look like in our practices? And in some cases, some of the ones that Shannon just mentioned, the clients basically self-identify financial exploitation. Or a family member or a friend will say, I don't know, the money's going fast. Or a senior will say, I think my credit card's being abused, or I signed a document and now I'm having a really queasy feeling. I'm not exactly sure what I signed. I thought it was for insurance, but now somebody told me I gave the property away. I mean, we get these calls. That happens when they actually identify or self-identify the exploitation issue, but very much more commonly, the senior or a concerned family member or a friend will call for assistance with other issues. And what we want to communicate today is that these issues, one civil legal issue on its face, but it can suggest, it should be interpreted as a red flag for exploitation, abuse, and neglect. And there's so many ways this comes up, but I just made a list of some of them, and I'll go through them kind of quickly.
Hey, Ellen, can I jump in for a second on the
Yeah.
facts in this? So statistically, you guys, the average number of times a person is exploited is 7 times.
Mhm.
7 times before they either run out of money or it's stopped by a family member. Like they get their stuff sold on the dark web and then they become a target. That's why all the phone calls increase. That's why all of a sudden people are at your front door. That's the reality. 7 times is how long it happens. And the average amount of money lost, $17,500 for a stranger scam. The average amount for someone that we know, caregiver, a friend, a neighbor, $52,500. How many people have that? It's never going to be recovered. So, this is like really stuff that's happening. So looking for these signs, I think, is very important, because you may not even know what's going on, but it can be devastating. And I mean, kill our victim.
Kill our victims, because this is not the group that's going to be able to recoup by getting another job. This is not the group that's going to be able to go back out and pull this back together. This can be a lifetime of savings, a lifetime of work gone. And frankly, the shame of it is as devastating as the financial loss. We're going to get into that in just a second. But when people call and say, we're really concerned, we can't get in touch with our senior relative or our senior friend, I don't know, they're not answering the phone, or I'm not sure that phone's still in service. And or they go and a durable power of attorney, and this is really ironic, but it's used as authority at the assisted living facility or the nursing home to restrict the permissible visitors.
Which it cannot do, by the way,
It
guys.
cannot do, guys.
Powers of attorney are only financial.
Yes, but if we had a dime for every facility that puts this in the visitor's notebook and or their and is restricting access on that basis, or calling the agent while the visitor stands there and informing them that they're there, we'd be very rich women. This happens all the time, even though that is not what a durable power of attorney is for. And it's not authority for a facility to restrict visitors. In fact, a nursing home resident, for one, has a right to see who he or she wants to see in Chapter 400. But if they don't know the visitors there, that they don't assert that right. The other thing that the abusers often do is they will tell the senior in a facility, you know, I don't know where your family is. You know, they haven't been to visit you. Oh, yeah, well, I'm here. Anyway, you get it. You get it. There's a reason that isolation without legal authority was added to the abuse definition in 2021, and this is it. Concerned friends, family will report an unexpected change in affect, like an anxious demeanor, physical condition, or a medical condition. Now, certainly advanced aging brings a lot of medical, physical issues. But when you hear a report of an apparently sudden and or dramatic change in demeanor, dramatic weight loss, unkempt status, it's a time to look a little harder, ask some more questions. People call and report that they don't understand it, but they've gotten a notice from the facility, a nursing home or assisted living facility, that they're in serious rent arrears, that their rent hasn't been paid for some time, and could they please do something about it? That's a real bad sign, because most people in these facilities have some arrangement for the periodic payment, to meet these periodic payments, because they're critical to their ability to stay there. If that stops, and in many cases stopped a long while before, that's worthy of further investigation. We hear about, seniors will call about collection cases for debts they're completely unaware of. A little research usually finds that these were debts incurred by another, misuse of the credit card, abuse of a credit card. And this is very different from what we used to hear all the time. The seniors, they still do call and say, I just signed on the second line. And they meant that they were co-signers. They say it all the time. I just signed on the second line. It's not my debt. But this is very different. We're talking about, in those cases, at least they know they were present and they signed on the second line. We're talking about cases where until collection calls begin, until sometimes a lawsuit is served, they have no idea about this debt. Not a good sign. We've had people call with Medicaid denials due to inappropriate asset transfers. What inappropriate asset transfer? This could be real property. It could be major transfers of funds. Very often the senior is unfortunately clueless. That's not a good sign. This is one Shannon talks about all the time. When you receive a call with an apparently random but very urgent request to change advance directives, to make, change the power of attorney, change the healthcare surrogate designation, redo the will. And this is especially especially dubious in the case in what we call the new friend context. When somebody like the neighbor who moved in next to Shannon's client is all of a sudden large and in charge, very much on the scene. And this has to be done right away after years of having these arrangements in place. And again, remember that one of the new provisions is to induce a change in a long-standing estate plan for nefarious reasons, not, that's a problem. And the new friends generally, that's really what that $10,000 less than 2-year permissive presumption is all about. It's people who befriend seniors sometimes. Sometimes the senior thinks there's a romantic involvement, but they befriend them. And the new friend is always just wonderful, very helpful, always present, but has this like unbelievable litany of troubles for which they need your money. There's the nephew with cancer. There's the ex-husband who stopped the alimony. There's the new friend has cancer, whatever. There's always a very pitiful list of worthy reasons that they need money, a lot of money, very quickly. And finally, the unwanted guests in the household. We've seen a lot of this, especially since the pandemic, when a lot of people lost jobs and then lost their housing. A lot of seniors who have a stable house or dwelling situation, accepting family members, adult children and grandchildren, friends down on their luck for whom they were trying to help them temporarily through a rough patch. Now, for whatever reason, the situation is not working out as well, and the guest can actually threaten the elder's security in many ways. We're not talking, by the way, just to be clear, about these cases where the resident, the guest resident isn't hanging up wet towels or something. We're talking about really toxic circumstances where smashing possessions in rage, punching holes in the wall, jeopardizing a senior's tenancy by the bad behavior. These are serious situations where the temporary pass is sometimes it works, sometimes it goes very wrong. And we're talking about those serious situations. I think I said, and finally, but there's one more that comes up sometimes. Even low-income folks usually have a sense of their own budget and do okay. They know what they can afford, they know what they can't afford. And when they report that they don't know why or what's going on, but usually manageable expenses are they just can't make it anymore. And yes, prices have gone up. Yes, benefits have not gone up to match the rise in prices. But when we hear people are splitting pills in half or not filling prescriptions because they cannot make the copay, and they always were able to before, again. So what comes next? Well, listen.
Ellen, can I jump in with just a couple more?
Yeah.
So one of the big indicators that I see a lot is with the phone, right? All of a sudden, family members' phone numbers are blocked. It usually starts off that they keep their phone number for a while. Our victim keeps the phone number for a while, but family members' numbers get blocked. Eventually, that changes to they get a new phone number, and only the people in the exploiter's world have the phone number. The other thing that I would say is changing where they do their banking. So if daughter was on as a joint account holder, mom might take her money out and put it at a new bank altogether. And, a lot of times this new person is on the joint account, but the old person doesn't know who the bank is, doesn't know where to look for these new assets. So that's another thing, is changing bank accounts. And then the only other one that I might mention is, like, all of a sudden we see that gifting, right? So they're gifting and they're loaning, and sometimes they can hide it, but other times they don't hide it. And they'll say, like, well, I had to gift her because she really needed it, yada, yada, yada. Like, no, that is not okay for you to gift when you don't have enough money for yourself, you know? So, it is important to kind of like start to put two and two together when some of these things are happening that may very well seem like, oh, she's just going through a rough patch or something. No, pay attention.
Pay attention. And that's, and y'all know this, but it never hurts to remind us all. Sometimes, especially in a long, busy day, it's hard to just listen, but these, you've all heard about trauma-informed advocacy. The kind of details we're discussing here are very difficult to divulge. They're embarrassing, they're hurtful, they often involve your children and grandchildren. They often involve your dignity. You were taken. And so I find that clients often start with other issues or the collection lawsuit or whatever, just straight up, this happened. But if you give it a little time, the very difficult details begin to emerge. And that's when you get to be able to put together the package. And so listen, ask questions. If the facts suggest, do some quick corroborating research. Check out the property appraiser's website. Check out the tax collector's website. These are all publicly available records. See whose name is on the property.
Yeah. And also, if you are acting as an agent or acting as a fiduciary for a person, if you're the attorney for a person, say, hey, why don't we run a credit report? Why don't we go ahead and get a credit report? Let's see what's going on. Because that will give you all the information related to that social security number of our victim. And then you can take
Excellent
a look
point. Yeah, and you can see what's going on.
Yeah. And I would also say, like, if your person comes in and you sit down with them and in about 3 minutes, they've told you all about their finances. They've told you everything about everything. They might be exploitable. Because if you're able to get that information without any kind of do you want to be my power of attorney? Would you be the one to help me manage my stuff? Like, they don't even know you, but they're willing to do that with you. That might be a sign to you that this is someone who needs protection. So pay attention
really
to this.
Good, if ironic point.
All right, let me just say it's 27 minutes.
Okay, well, we're going to pick up the pace here because we have a few more important things to say. Ask them after you do that research, the credit report's a great one. Ask them what steps they've already taken. You'd be amazed how many times people have some awareness that something is amiss and have been to law enforcement. They've gone to the police, but they call us when they've been told it's a civil matter and that they need to go to small claims. So to understand this and perhaps to get a different result, I just thought right quick, we could go through some of the really common misconceptions, or I call this this can't be exploitation because column. And Shannon went through some of them, but they're so important because these cases have to be investigated. And this can't be the end of the line. I've had law enforcement tell me that the victim is so with it. He knew exactly what he was doing. Mm-hmm. We don't have to go back to the exploitable brain, but knowing exactly what he was doing is not the point. It's simply not, it may be, but it's not always the point. The alleged perpetrator is the agent with a durable power of attorney. I think we've been through that. A durable power of attorney is not a magic shield or a magic sword to do anything you want. As they used to say back in the day, a power of attorney is not a license to steal. The senior and the alleged perpetrator have a joint bank account. Shannon told you where it says in 825.103. Yes, a joint account holder is allowed to withdraw funds, and the bank will always let that person do it because that's what joint account holders get to do. But that joint account holder is not allowed to divert funds or misappropriate funds as long as the perpetrator has put nary $1 into that account. That's really important, but they never have, at least not in my cases. They've never contributed. This business about the gift or the consent, again, if we can cite you chapter and verse, why that simply isn't a defense. The senior allowed the perpetrator to use the credit card to pick up the groceries on 1, 2, or 3 occasions, always receiving the card back. That doesn't mean you can book a trip to Aruba. That's just that permission to run in and get the groceries, especially if you're mobility impaired and you let someone else run in and pick it up. That doesn't mean they can use it for themselves. That is not consent. And finally, if a senior goes to law enforcement with a contract of any sort, that's a civil matter for sure. Well, yes, of course it's a civil matter. It also can be a business relationship under 825.103 and or civil theft. And we just have to find out more about it. In fact, there are statutes like we know about contractor fraud statutes where if somebody gets more than 10% of the total estimate and does nothing or doesn't do it, timely, there are some details. There are certain presumptions arise, okay, of fraudulent intent and that sort of thing. So when all this happens, what about the relief? What do we do? Well, Shannon has some really creative preventive steps she takes. I love this. It's called trust-based planning. And we don't have a lot of time, but the best situation is to talk to a senior before there's a problem and when you're planning for it. And I do want to get to removing people and from when the person is the problem. But Shannon, do you want to tell them a little bit about that trust-based planning?
Sure. And actually, I think there's really 5 good tools that we can use to prevent exploitation. So I often have clients come in and we're doing their estate planning, and most of them are older. And I say, do you want to try and prevent exploitation? I tell them a little bit about why that might, 1 in 5 will be exploited. We know about some of the statistics that exist related to exploitation. I've never had a client say, I don't want it. They all have fear that they will become exploitable and that their money will be gone because, it happened to their neighbor, it happened to their friend. So trust-based planning, if the assets are titled in the name of the trust, is one technique that we can use to try and prevent exploitation, because we give authority to our successor trustee to step in and take over as a successor trustee. And if all your assets are titled inside the trust, then that locks the trust assets down. And so, one of the advantages of that is that then the trustee is not our victim. So when the exploiter comes to get money, the victim can say, I'm not the trustee of my trust. It's my son, Johnny. You'll have to go talk to him. And isn't it great? Because Johnny's not going to give you a dime. So it also empowers our victims to say, like, I'm just not in charge of that anymore. So trust-based planning can be very effective. Here's something that I love, and all of our clients who are of advanced age use this tool. It's called the Careful app. And it's Careful with 2 L's, CAREFULL. No, I'm not paid by them. I have no affiliation with them, but I love them because they've created a tool that we can all use, and it's not being used enough. Basically, it is a monitoring tool that has algorithms. So if you are a vulnerable adult and you put all your bank accounts into the app, And what we see is if your bills don't get paid on time, or if you pay a bill twice, or you're trying to send money overseas to a nefarious recipient, the algorithm of the app sends out a notification to your trusted contacts. So if you have people that you trust, they're going to get notified that you've just sent, $1,000 to a nefarious country. And then they can take the steps to, kind of intervene. It does not create a lack of independence. So our people like it because they're not giving authority to anybody. They still have the ability to manage their finances. It's just a monitoring tool. So the Careful app is great. It's like $10 a month. So it's super inexpensive. I mean, yes, that is an expense, but honestly, the peace of mind that comes with that app has been invaluable to our clients. The other thing is using trusted contacts with financial advisors. So if they have investment accounts, IRAs, and they have an actual financial advisor, assigning trusted contacts who the financial advisor can reach out to if they have concerns about transactions that are going down, it's invaluable, again, to stop all your money from being sent away. The fourth one is the pre-need consent against exploitation. This is a tool we basically just developed once the exploitation injunction became part of our statutes. And that is to say in advance, I want these people to be able to file an emergency petition for exploitation injunction on my behalf. Here I am, I'm signing my consent right now, and you can use it in the future if I become exploitable. And then you just attach that consent to your exploitation injunction petition. The judge reads it, they're like, this is great. Yes, of course, they've consented. And so it gives us another tool so that when we want to file that injunction, we already have the consent in place. And then, of course, including provisions in durable power of attorney documents that say, if it looks like I'm giving my stuff away, even if I'm objecting, I want my agent under power of attorney to be able to file that injunction on my behalf. So those are really the 5 top tools that we use to prevent exploitation.
Okay.
Got you, Ellen.
Okie dokie. Well,
Trying to be quick.
Well, I'm gonna be quick. One thing I really want to get to, we're going to skip a little bit, but I do want to discuss this very real situation that I fear is going to increase, which is when your problem is living in your house. When your problem is that person who was there initially with your consent, some more freely given than others, but that arrangement has become toxic. It's no longer working, and in fact, it's dangerous. What happens? What can we do? How can we help our clients help them move this person out when they refuse to go on their own? And again, like I said, this isn't about the wet towels. This is seriously threatening, abusive, dangerous, exploitative behavior. So there, if I hope many of you had a chance to hear Jeff Hearn yesterday talk about unlawful detainers. He did an excellent job, and with an overview of this tool that's been part of Florida statutes forever. And if you didn't get a chance to do it when you get the recording, very, very helpful. So unlawful detainer, I want to give you the pros and the cons. The pros are that unlawful detainer is kind of stunningly simple. It says that if it's a short complaint, it's an expedited procedure, kind of like an eviction, expedited, very short response time, very short timeline. And the complaint simply alleges that the plaintiff, our embattled senior, the plaintiff has a legal right to the premises, whether he or she is record title holder or the sole tenant on the lease, that our senior has a right to be there. And the defendant does not have any legal interest in the premises, that the person was there with permission, that permission's been revoked, they've been asked to leave, and they won't vacate. That is pretty much that. And so it's a simple, straightforward complaint. And as Jeff mentioned yesterday in one subsection, the legislature saw fit to put that unlawful detainer is a focus on the right to exclude others as one of the most essential components of property rights, okay? And also the relationship between the parties is irrelevant. It doesn't matter if they're related, it doesn't matter if they're not related. The whole point is when one person has a right to the premises and the other doesn't. And that's pretty much that. Sounds simple. Here are the cons. Nothing is simple. So there's a filing fee. Yes, many of our clients have very, very low income, but the asset level for the approval of an application for declaration of civil indigency is also quite low. So some of our seniors who have managed to cobble together a bit of a nest egg will not get that indigency waiver of fees, okay? So there's a fee. Potentially, there's a not so summary timeline, despite the fact that it's an expedited procedure. First, you file the complaint, but then it has to be served. It's served and the defendant does have a short response period, but still 5 days, not including the day of service. Weekend or legal holidays, already we're beyond 5 days. Then the hearing happens. Let's say, and we can almost assume our plaintiff will prevail because he or she has that legal interest and the defendant doesn't. But I've just heard this from a colleague here at Bay Area. There's a backlog on the service of the writ of possessions. So a procedure that, yes, is meant to be summary, but you now have a vulnerable adult with the problem in his or her house who was served, knows you want them out, they're threatened, and here the two of you are just chilling or not. And that's a very, very dangerous situation, a very bad time, I think. So there's that. Even if it's not a actually harmful situation, the risk of undue influence is very, very high at that time. Mom, dad, let's just forget this, okay? Let's just forget this.
Yes.
This is really dangerous stuff. So is there any other remedy? Oh, possibly you can use the exploitation injunction to accomplish the removal, if you will. And there are some great pros. There is no filing fee. It's ex parte. There's an immediate effect. That person can be removed right away.
Yeah.
Even though it's time limited. It may be combined with other protective orders like no contact orders. No, they can't contact you by phone, by text.
It's not limited. It's not limited, Ellen. You can make it permanent in your final injunction
And you
order.
can make it permanent. And that's the wonderful thing. You can make it permanent. But that's why I said earlier, if there should be an extension or a continuance, it's wonderful because this protective order can go along until you can get back into court. And then hopefully it can be made permanent.
Right.
And that's a really good thing. What are the cons? Well, it's the exploitation injunction is a fact-intensive pleading. It's not this straightforward, bloodless, you have a legal interest or you don't. This is, you have to satisfy the traditional injunction requirements, as Shannon was saying. You have to show imminent risk of harm, imminent risk of irreparable harm, likelihood of success on the merits, no readily available legal remedy, and no major detriment to the respondent. That's a case to be made. That's no small thing. Also, the relationship between the parties is relevant. You have to show 825.103 tells us who is within the ambit of that statute. And it's not just anybody. And if the perpetrator, the alleged perpetrator, the respondent is the caregiver, you have to affirmatively plead the arrangements you've made to substitute the caregiving services if that caregiver is removed during the injunction, by the injunction. Okay, these are again no small thing. And then the motion to modify or dismiss, as Shannon said, can be filed by any party at any time, and the court has to hear it expeditiously. So that makes it even more important with either the exploitation injunction as a removal tool or unlawful detainer. As far as I'm concerned, the top priority here is the vulnerable adult safety. So before you use either of these tools, make a safety plan. And with low-income folks, sometimes there aren't that many great options, but you have to be cognizant of the fact that process is going to be served at one point or another, whichever remedy is chosen. And there's that response period and until the final hearing. And imagine if it was bad enough for the senior to reach out to you to begin with, how do you think service of process is gonna affect that situation? Probably not real well. So these are difficult situations. They can be incredibly helpful. You can get relief for those people, but be cognizant, get a safety plan in place, arrange for the petitioners or the plaintiff to be elsewhere if at all possible during this period. And then really, it can be a very, very positive outcome. And that, I see Kathy is back, and I see
Just to say 8 minutes.
8 minutes. Well, I want to make sure, are there any questions, Kathy? Does anyone have a question?
No questions at this point. No new
Okay.
questions.
Okay.
Let's dig into exploitation injunction.
Yes,
We kind of
yes.
glossed over it a little bit. And unless there's some other topic that you want to hit
No,
on.
that's good.
Okay, so let's talk about the process, because boom, you don't need an attorney, right? Now, Ellen and Nancy and I put together a video that is really, I think, I mean, it's still pretty relevant, although we've learned some tricks of the trade since that time. I would love to share a whole bunch of tricks of the trade, because there's a lot of really good strategies.
Go.
But for the most part, here's the process, right? Client comes to you, you're ready to file, you get all your facts. You want to make sure you have your evidence ready. So that can mean reaching out to the bank, getting the bank statements, getting a certification of the records custodian, so you don't have to bring them in as a witness for your final hearing. Get all your ducks in a row. Get all your witnesses ready. Go ahead and talk to them. Make sure that you understand what your evidence is and how it's going to play out in court before you file your temporary injunction petition. Because once you file that temporary injunction petition, which requires no filing fee, but they can back charge a fee, which no one ever does. So, but once you file that temporary injunction petition, everything's going to go very quickly. Our judges will set the hearing really within at the most 15 days, but most of them set it within 5 to 7 days. So you're going to get your order back like the next day. That creates the no contact provision, that freezes the assets. There's a way in your petition for you to say, we want to freeze the assets, but we also need the mortgage to be paid. We need the light bill to be paid. There's a technique for putting that in your petition to say, we need these 7 checks to be paid out on these dates. And banks will go, no, we can't do it, it's too hard. Yes, you can. You do it in guardianship cases all the time. So I like to prep the banker. I like to get them on the phone. I like to say, listen, banker, we love our little person who's your client. This is what's happened. Some stuff's going to go down. We need your cooperation. this is what's going to happen. This is what the proposed order looks like. Are you okay with it? This is really going to help our community to stop exploitation. And you develop those relationships with your potential witness, who then gives you the records and does the certification of the records custodian. So you don't have to bring the banker in. You can just submit these records. There's usually no objection. And then the other thing that we do, and I'm just going to try not to spend too much time on this, is when we're ready to go to the hearing, what does our respondent, our exploiter, always want to do? They want to tell us why this is not exploitation, that it was a gift. So when we walk into the exploitation injunction hearing, one of the first things that we ask for is for the court to give an instruction on the right to remain silent. We know that every exploitation injunction hearing is recorded. The judge will give the instruction. Sometimes our respondent will be quiet. Most of the time they won't. And sometimes they even come with an attorney. And most of the time the instruction is given, but the attorney still lets the client go and testify to how they've committed exploitation. It's unbelievable. And all of this is recorded. So at the end of this hearing that you've had, where you've basically had your defendant admit to exploiting, because it's a joint account, but the victim wanted them to have it. And yes, they are a vulnerable adult. All of this happens on the record. You tie it in a bow and you send it over to the state attorney's office to prosecute the crime. So, the exploitation injunction process is incredibly quick. You've got to have everything ready for your final hearing before you file your temporary petition, because the order is going to come back the next day and you might be set within 5 days. So have everything ready before you file anything with the court, or else you're going to be caught with not telling your witnesses it's going to happen very quickly, without prepping your witnesses, without having your evidence ready. So that is one thing about it. On this idea of modification of injunctions, I've had like 4 or 5 petitions been filed with modification requests. They never modify it. They just don't. They just don't do it. And, I've had.
And that's good to hear. I mostly brought it up because the point is, if you want to remove that troublemaker from the household, because that's when the undue influence comes in. And that's when they try to talk our client into dropping everything.
Yeah.
And that's so dangerous.
The other thing that I like to encourage people to use is the injunction petition builder, which also, we know that's
Good point.
elder risk detector. So that can be found at, I saw Sarah Helsel's in our chat.
On the DOEA website.
Yeah, but I don't know the direct, I know it used to be floridaelderlaw.org. I think you can still go to that particular website and it takes you to the Department of Elder Affairs website. The other thing, seniors versus crimes.
Seniors versus crime. Absolutely. Make the call.
Yeah.
And we didn't get to the abuse hotline, which of course is required, by the way. A call to the abuse hotline is a required assertion in your petition. You have to say that you swear that you have made this call.
That's right.
Very, very important. And in certain cases, a domestic violence injunction will be appropriate. But remember, a narrow range of perpetrators is covered by that particular protective order.